let us return to the case. Let's review a bit the facts of the case. So, as earlier mentioned, during the several settings of conferences between the parties, all the parties from the respondent, Belen, down to all the defendants were all present, and they have agreed the partition of the properties located in different areas of the Philippines. The parties have already agreed what is supposed to be the properties allotted to each one of them. Okay? So because of that agreement, the regional trial court then instructed the lawyer of Belen to prepare a written instrument to record the compromise agreement of the parties. No? So it appears, however, that the petitioner Victoria, one of the defendants, was not able to sign the written instrument recording the compromise agreement of the parties because of her absence on the schedule fixed by them, which was for the purpose of the parties signing the written instrument recording their compromise agreement. Okay? But despite her absence, however, during the last conference between the parties, the petitioner Victoria was present and she agreed first on the partition made between them of the properties located in certain regions, and also agreed with their respective shares of the properties located in the other regions of the Philippines. Thus, the regional trial court likewise noted the fact that the counsel, the lawyer of the petitioner Victoria, explained that the sole reason, the only reason why the petitioner Victoria was not able to sign the document was because she has no money for transportation. Okay, quote. The sole reason she has no money for transportation, and not because the petitioner Victoria disagreed with the terms of the compromise agreement. The truth of the matter is that the parties had already previously arrived at an agreement with respect to the partition of their late mother's estate. So there was already an agreement. It was just an oral agreement, and the only thing that was lacking was the signature of Victoria on the written instrument recording the oral agreement. Okay? According to the decision, after a review of the records of the case, the Court of Appeals also established the following facts. Okay? The evidence of the parties show that they entered into a valid oral partition. So this is one of the important lessons sa case, no? There is such a thing as valid oral partition of the estate. Okay? So the parties negotiated terms and provisions of the compromise agreement, and they settled. They agreed. Okay? The compromise agreement was executed only to reduce into writing the oral partition already validly agreed upon by the parties. Okay? So the written instrument entitled compromise agreement was executed only to reduce into writing, to record into written form the oral partition already validly agreed upon by the parties. At this juncture, it must be stressed that, as a rule, in an appeal by certiorari under Rule 45, the court does not pass upon questions of fact, as the factual findings of the trial and appellate courts are binding on the court. The court is not a trier of facts, no? The Honorable Supreme Court. Hence, to disprove the factual findings of the Regional Trial Court and the Court of Appeals that there was already a valid and binding agreement that was entered into by the parties during the mediation conferences before the Philippine Mediation Center, it was incumbent on the part of the petitioner Victoria to provide clear and convincing evidence to substantiate her claim that she never reached an agreement with her siblings as to the partition of their late mother's estate during the mediation conferences. No. However, the court finds that the petitioner Victoria failed to do so. Okay? Aside from her mere self-serving statements, no other evidence was provided to support her claim. no evidence, only statements, no? Only allegations. In fact, petitioner Victoria's actuations lend more credence to the fact that she fully consented to the terms encapsulated in the compromise agreement. From the signing of the aforesaid document on the schedule set for that signing until the time the regional trial court rendered a judgment on compromise, there has not been even a whimper coming from the petitioner Victoria contesting the compromise agreement. So, mo na position no, sa Honorable Supreme Court. If the compromise agreement indeed failed to capture the real agreement reached by the parties during the mediation conferences, petitioner Victoria would have raised the matter before the regional trial court. It should also be pointed out that early on, the mediator had already issued an order to reduce into writing the agreement already reached upon by the parties. So, the circumstances really affirm the fact that there was already a valid oral partition. Okay. So we will read further the decision of the Honorable Supreme Court in this case in the next video. Okay. So we will see each other in the next video and let's go through further with the decision of the Honorable Supreme Court. Okay. So I'll see you in the next episode.